Even though we call this country the U.S. or the U.S. of A., it's not. It's not even known as just America. When you look at a map of the country, it's labeled North America.
And welcome to Facts or Frauds. Now let's head to the Superior Court of Fulton County, Georgia, for another sovereign citizen in front of Judge McBurney.
Good afternoon, Mr. Pierce.
Good afternoon.
How are you?
Fine.
Good. I'm hanging in there. It's been a long day, but I'm sure it's been a long day for you as well. Whoop. Let's get your stuff all situated.
Y'all sit down, man. Y'all sit down.
Okay, well, you've waved to him, but this isn't a place where we have that kind of conversation. You bet. Mr. Pierce, when we were last together, we had a conversation about representation, and you told me that you wanted to represent yourself. You didn't want a lawyer appointed, and you weren't going to be hiring a lawyer. And I said, we can have that conversation. That's an extended conversation, judge and defendant. And I'm ready to do that so that we can move your case forward. Otherwise, you're kind of stuck until we clear that hurdle. You have a right to represent yourself, but I need to make sure that you are knowingly invoking that right and intelligently, which is not me telling you you're not intelligent. I just need to make sure you understand the consequences of self-representation. So that's what I was hoping we could get through today. But I always want to start by saying what is on your agenda so we can see if there's anything else.
I'm American State National, and I can't be represented by no attorney. But I have a lot of issues with me being a national that I wanted to address. You said you were going to let me hear me. You're going to let me address all my issues last time I was here about me being.
Well, I did say that, but I said if you're going to address issues, I need to make sure you're representing yourself. Okay, but if we're going to do that, we have to have my conversation first. I'm required by law and by the Constitution to go through a few things to make sure it's appropriate for you to represent yourself. So you can want to do it, but I got to make sure it's appropriate to let you do it. I'll just give you an example. Let's say that you were deaf. That might make self-representation kind of complicated. You're not deaf, and so you can hear me and I can hear you. But I need to ask you a bunch of questions about your background and make sure you understand the consequences of being your own lawyer. If you assure me that you got it and getting all those things you want to represent yourself, I have to give you that right, and I will. And then you can share with me what your issues are. Okay? You ready to work it that way?
Yes, sir.
Excellent. Let me get one thing here and we can get started. All right. Mr. Pierce, please tell me how old you are.
41 years old.
How far did you go in school?
11th grade.
All right. Did you ever get your GED?
Yes, sir.
When did you get your GED?
2017.
Excellent. Are you able to read English?
Yes, sir.
I know you can write in English because I got these and you actually mailed me something that
Yeah, I wrote you a letter.
about 200 pages long. All right. So you can read and write and you can speak English. Have you ever worked before?
Yes, I had several jobs.
Tell me what kind of work you've done before.
I worked for Dollar Tree when I got arrested. I worked there for Airmark. I worked there for the Move Theater in North Carolina. I have my own landscaping business. I have my own record label. I worked at McDonald's, Burger King.
You've had a bunch of jobs. Got it. All right. That's helpful to know. I appreciate you sharing that. Have you gone to law school?
I haven't gone to law school, but I have practiced, not practiced, I've been studying law.
You've been studying the law. Tell me how you studied that.
Just reading, researching different case laws, sending out different statutes and codes and things of that nature.
Sure. Has all of your legal study been while you've been in jail, or have you also done legal study when you were out?
Both in and out.
Okay. Got it. Have you ever watched an entire criminal trial before, start to finish?
I done been to trial before.
So you've watched one then?
Yes.
Okay. What was that trial about?
Armed robbery. The 10 years I just did for armed robbery.
So you were charged with armed robbery.
Yeah.
And that case went to trial.
Yes, sir.
So you were there from jury selection all the way through verdict.
To closing argument. I stopped before closing arguments and took 10 years.
Oh, you pled guilty.
Yeah,
Got
I tried right before they were finna come out for closing argument.
So you've seen 95% of a trial.
Yes, sir.
All right. You ever watched a trial on TV?
Yes, sir.
What kind of trial?
What that movie that's so called? Law and Order.
Okay, you've seen that kind of stuff. So you've seen the made for TV stuff.
Right.
But you've been in a real one. You were a participant in a real trial.
Yes, sir.
How long ago was that trial?
2016.
Where?
Here.
Fulton County.
Yes, sir.
Who was your lawyer?
Kevin Farm. He's a judge now.
He is. That's a small world.
Yeah.
All right. Have you ever represented yourself in a criminal or a civil case before?
No, I haven't.
This would be your first time.
Yes, sir.
Got it. Have you ever gone to a doctor or a counselor to get treatment for any mental health issue?
No, sir.
Depression or bipolar or anything?
No, sir.
Okay. Tell me why you think you would do a better job representing yourself than a trained lawyer who went to law school and has done trials before would do.
Because by me being a Mr. National, a lawyer only subject me to the jurisdiction.
So hold on 1 second. Yeah, you got it. So the court reporter needs to be able to take down what you're saying. What you're saying is important. So just don't rattle the change, and then she'll be better able to hear you. So you were telling me by being an American
State national, and by me being a national, I can't be represented by an attorney because attorney automatically subject me to the court's jurisdiction.
Okay. So my question was a little different. I hear you. But my question is, why do you think you would do a better job than a lawyer? It sounds like you may think a lawyer would do a better job, but you don't want a lawyer because you're worried that would subject you to the jurisdiction of this court.
I know for a fact it'll subject me to the, because a lawyer is as an officer of the court, and by them being an officer of the court, it automatically subject me to the court's jurisdiction.
Okay. Well, indulge me for a minute and assume, you may think I'm wrong, but assume that I've decided that you are subject to the jurisdiction of the court. And you say, Judge, you're wrong. Okay. But I get to make the decision initially. And then you go to the Court of Appeals and they'll say McBurney was right, McBurney was wrong. But if I've decided that this court has jurisdiction over you and this case and your co-defendant, do you want me to appoint you a lawyer because you're stuck here anyway? Or you still want to represent yourself?
I still want to represent myself because I'm not under the court jurisdiction.
No chains.
Okay, my bad. My apologies. I'm not under the court jurisdiction, and I've been studying it long enough. Almost my whole family is nationals, and we know pretty much a lot about it. And we know for a fact the only way I could be subjected to a court jurisdiction is through a lawyer, because the birth certificate is a void contract, and through that contract, the birth certificate contract is what makes me subjected to the court jurisdiction.
Okay. I'm going to stop you again, not because I'm disagreeing with you. I am disagreeing with you, but we don't need to resolve that right now. I want to keep going with the discussion about representation. Before I get to the next question about the consequences of self-representation, if we fast forward and play this out, eventually you are either going to be pleading guilty in this case or you're going to trial. You're going to disagree about jurisdiction. I'm going to be very respectful and say, you know what? I hear you, Mr. Pierce, and you don't think I have jurisdiction or this court has jurisdiction over you. And I may be wrong about that, but we're still moving forward. Here comes a jury. We're going to do the trial. And so we'll go through that whole process. And I may be told I'm wrong by the Supreme Court, and then I'll have to fix that, and I will fix it. But there'll be this trial. You're going to want to represent yourself, even though we're going forward with it.
Yes.
Okay. Do you know what you're charged with in the indictment?
No, I haven't had. I know what I'm charged, but I haven't had nobody come talk to me about nothing. I don't know what's going on. I don't know.
Well, that's because you've said you don't want a lawyer. And so this is what we're getting into. No one's going to come talk to you about what's going on. I'll make sure you get the discovery, the paperwork in the case.
And when would I?
It's complicated. We can get you the paper stuff pretty soon.
Okay.
But if I'm making this up, I don't know what's in the case. But if there's video, let's say there's surveillance video, I can't give you that at the jail. It's on a disc. What are you going to do with a disc at the jail? You can't watch that. You don't have a way to watch that.
And, I would be signing a private investigator too, right? By me representing myself?
Nope. You don't get an
How would I
investigator.
do my investigations and this part of the process?
Well, we're going to talk about that, but you don't, I mean, that's a reason to say, you know what, I will take a lawyer because that lawyer will have an investigator and that investigator.
But can I hire my own private
Well,
investigator?
with your money, if you got money for it, you can hire anyone you want. But I won't be providing you money to go hire an investigator because you're saying I'm handling it myself. I got this. Mr. Pierce has it, which means your family would be, they could be helping you or an investigator or something like that. Or there may be some way, and I can't teach you how to do it, where you could petition to get funds for an investigator, but that's not for today. One of the consequences of representing yourself is there isn't someone who comes and sits down with you and say, let's look at this discovery. Man, the way the police handled that looks like that's a problem to me. I've been a lawyer for 20 years. I've never seen a police officer do that. That's something a lawyer could tell you after he or she reviewed all the discovery. And you won't get you're not a dummy. You could look at it and say, hey, this looks suspect, but you'd be making that decision without a lawyer helping you think about it if you represent yourself. Do you understand that?
Yes, sir.
Okay. But you seem concerned that someone hasn't already come to the jail to talk to you about what's in the indictment.
I'm not concerned. I was just,
Okay.
wasn't informed on it. I
Right.
know I was supposed to get a discovery package at least, or
Well, not yet.
report an indictment or something.
You will get it if in the end you convince me that I should let you represent yourself, then you will get all that stuff. But no one should have given you anything yet because we're on hold. Is he going to have a lawyer? Then we give the discovery to the lawyer who works with you on that. Or is he representing himself? Then we give the discovery to Mr. Pierce. And right now you're saying, I want to represent myself. And if we get through this conversation, then you'll start getting discovery. Let me tell you what you're charged with in the indictment. Count 1 charges you with murder, and it alleges that you and Mr. Baker shot and killed Samuel Curtis Harris Jr. That's count 1. Counts 2, 3, 4, 5, and 6 are all, and 7 and 8 are all what we call felony murder, which is you and Mr. Baker caused the death of Mr. Harris by being involved in a different crime: attempted robbery, armed robbery, aggravated assault, being a convicted felon, and having a firearm. Although that's just Brandon Baker. Brandon Baker apparently was a convicted felon at the time of this murder, and the murder was in February of last year. Oh, you are too. There you are. So you had a felony conviction as well. You and Mr. Baker are charged with attempted robbery, and the allegation is, and again, these are just allegations. It's not proof of anything, but it's letting you know what you're charged with and what you'll need to defend against.
Okay.
But the attempted robbery allegation is that in February of 2024, you and Mr. Baker approached Samuel Curtis Harris Jr. on foot on Mitchell Street, right near here, with the intent to take his property. Count 10 charges you and Mr. Baker with armed robbery, saying, in fact, by using a gun, you took his property. In fact, what you took from him was a firearm. Count 11 charges you both with aggravated assault for shooting Mr. Harris. 12 is possessing a gun in connection with these crimes that I talked about. Same with 13. 14 is just Mr. Baker. 15 is you. And it says that on that date, you had a firearm, but you were a convicted felon because back in 2010, you got convicted of something in Clayton County. And also, you got convicted of something here in Fulton County in 2016. I guess that's your robbery you were talking about.
Yeah.
So the thrust of it is, the allegation is you and Mr. Baker robbed Mr. Harris and shot him, and he died as a result of that. That's what you're charged with. Today is not the day to say, I didn't do it, it was self-defense, I wasn't there. That's your defense for another time. That's what you're charged with. So,
Because I have it now?
pardon me?
How many counts I have it now?
It is,
Because I came here having 6 charges.
it's about 12 charges, but a lot of them overlap. 1 count of murder, several felony murder counts, because each of those other things I mentioned, the attempted robbery, the armed robbery, the aggravated assault, that creates a felony murder count. And then you've got a couple charges, all for possessing the same gun, but because of your criminal history, it can be charged in different ways.
But they got me charged with 3 different possession charges.
1 for possession of a firearm during the commission of a felony, and then 2 possession of a firearm by convicted felon, because you have a serious violent felony, your armed robbery, that leads to 1 type of possession charge, and the other, you've got this escape conviction out of Clayton, and that supports a different type of charge for possession.
And what that charge is?
It's possession of a firearm by a convicted felon, but it's a different type of convicted
I
felon.
got 2 possession of firearms.
You do? Yep. And those may not be good charges. I don't know. That's what you would talk to your lawyer about, or that you'd research on your own if you're representing yourself.
All right.
All right. Do you understand what the penalties are for these charges?
Yes.
You understand that for this murder charge, you could be sentenced all the way up to life without parole, meaning you would die in prison.
Yes.
Same with all the felony murders.
Yes.
You understand that they'd all merge. You can't get more than 1 life sentence for the murders.
Say it again.
You cannot get more than 1 life sentence for the murders. You understand that?
Mm-hmm.
They'd all merge together. But depending on how the case played out, armed robbery also, you could be sentenced up to life in prison. You understand that?
Right.
Okay. And then the other offenses, they're lower sentences, but still serious. But the big one is murder with the possibility, not the guarantee, but the possibility of life or life without parole. You understand that?
Yes.
Okay. Are you a U.S. citizen?
Yes.
Do you understand that if
I'm not a United States citizen.
well, let me, I'm not trying to trick you. Were you born in the United States?
I'm not a United States citizen. I'm a American state national.
Okay. Tell me where you were born.
I was born at Greater Hospital.
All right. A Grady baby. That's all I need to know. There are a bunch of questions I can skip if you were born at Grady Hospital. If I decide that it is appropriate for you to represent yourself, do you understand that you don't get to change your mind partway through the trial?
What you mean?
Well, here's an example. In your armed robbery trial, you were able towards the very end to say, you know what, I want to plead guilty. I want to switch it up. I'm going to plead. Let's take this away from the jury. If you go to trial as your own lawyer and we get partway through and you realize, dang, this is harder than I thought. I don't really know what I'm doing. You don't get a call, a timeout and say, Judge, find me a lawyer.
Oh, yeah.
If we start representing yourself, we finish representing yourself. Start to finish, you understand?
Okay, so if I represent myself, later on down, I can't have my family hire me a lawyer.
That's different. That's different. I wouldn't appoint a lawyer.
Okay.
You could bring in a hired lawyer whenever you want, knowing that if we're in the middle of trial, you could bring someone in, but we're not going to pause the trial. That person would have to jump down next to you and say, I'm ready to go. That person couldn't say, well, I need a week to get ready. But you'd be telling a lawyer, this is a strange assignment. You're going to come represent Mr. Pierce, and he's actually on day 2 of the trial. But some lawyers might be willing to do that. So yes, your family could hire a lawyer tomorrow, next month, next week, next year. Hopefully we'll be done with your case before then. But what you could not do in the middle of trial is say, Judge, I quit. You need to go get me a lawyer. Understand? Okay. Do you understand that in almost every instance, self-representation, you being your own lawyer, is a bad idea?
That's personal opinion, right?
It is a personal opinion. I'm giving you my opinion. I think it's a bad idea.
Why?
Well, I'm about to get to that. Do you understand that if you represent yourself, you are not entitled to any special treatment? There's not a Mr. Pierce rule like, hey, he doesn't know this rule. I'm not going to apply the hearsay rules to him because he doesn't know what hearsay is. Do you understand that? Whatever rules apply to the state, and if you had a lawyer, your lawyer, they're going to be the same rules for you.
Understood.
So if you are asking questions of a witness and you really, really, really want to get this exhibit in, Judge, I need to let the jury see this. If you don't know what questions you're supposed to ask to get it in, I don't say, psst, ask these 3 questions. You got to figure it out on your own. And if you can't, then this doesn't come in as evidence. You understand that?
I thought you were supposed to admit the evidence before you start trial.
Well, sometimes it works that way, sometimes it doesn't. It can work that way, but sometimes in the middle of trial, like, hey, you know what? I want to admit this now. But you don't get to ask me questions about how do I do this thing.
Oh, yeah,
If there's an objection and I sustain it, and you look kind of confused, you're just going to stay confused. I don't take a time out, have the jury leave the room and say, here are the 3 things you need to do to get this piece of evidence in. You understand that?
Yes.
That's one of the reasons why I think it's a bad idea, because I know you're smart and I know you've been doing some legal research, but I also know that you're not a trial lawyer. And so you might not know how to get something into evidence because you don't know which questions to ask, but you're aware of that. You know that's the rules. Do you understand, Mr. Pierce, that by choosing to represent yourself, you may miss possible defenses, legal arguments that a lawyer could make on your behalf to try to convince the jury to find you not guilty? Understand that?
Yes.
Yes? Okay. Do you understand that anytime that you fail to make what would be a valid objection, let's say the prosecutor is asking a leading question, and if you objected, I'd sustain it. If you fail to object, that evidence is coming in, and you don't get on appeal, say, wait, that evidence came in. Because if someone doesn't object, that's not anything that can ever be appealed. Do you understand that?
Yeah.
Okay. Do you understand that I will not be making objections on your behalf? I may be thinking, this prosecutor is breaking every rule in the book with these questions, but they're rules of evidence. And it's not my job to hit the buzzer and say, that's not a fair question. It's your job to hit the buzzer and say, I object. You understand that?
Yes, sir.
And I won't give you a little signal like a wink saying, hey, now's the time to object. It's you're on your own, sink or swim. You understand that?
Understood.
Okay. Do you understand that unless you take the stand and testify, none of the words that you say to the jury will be evidence in the case?
What you mean?
So lawyers are, you saw your trial. You said, hey, it ended before closings. That means you saw openings, opening statement. Then when the prosecutor got up and said, Pierce is a bad man, he did an armed robbery, you'll hear the evidence, and he held a gun to someone, whatever they thought the evidence would be. None of that is evidence. All of that is the lawyer talking, saying, here's what you may hear. You'd be free to give an opening too. And your opening might be, I wasn't there. It was all Mr. Baker. You're going to hear evidence that I was in Louisiana when this crime happened. That's not evidence that you were in Louisiana. That's just you talking to the jury. And I'll be telling the jury that nothing that you say when you're giving your opening or that the prosecutor says while she's giving her opening is evidence. It's just some guidelines that the jurors could choose to follow as they're thinking about what the case is about. The only way you would get evidence in is if you choose to testify or if you figure out how to admit exhibits.
Question.
Yeah.
What's the difference from me starting an open argument and a lawyer starting an open argument? It'll be admitted evidence if a lawyer start an open argument.
It's not. Nope. I tell the jury before we start the trial that you're going to hear from, if you represent yourself, I won't say the lawyer, I'll say you'll hear from both sides. You're going to hear from both sides an opening statement. That's not evidence. It is a preview of what each side thinks the case is about, but it's not evidence. And you didn't get to hear this because you pled out before then, but I would say, as would any judge before closing arguments, you're about to hear closing arguments. These are not evidence. These are arguments from both sides saying, here's what the evidence showed, or here's what the evidence failed to show. Evidence only comes in through someone who's under oath on the witness stand or when an exhibit is admitted, which means if you wanted to testify to get evidence in, you'd need to take the stand. And the reason for that is that's because the state gets a chance to ask you questions too. Right. Otherwise, you could just get up and give an opening saying, I didn't do it, or it was self-defense, all that kind of stuff. And you can say those things in your opening, but it's not evidence. And I'll tell the jury that. And so if you chose not to testify in your trial and you didn't put up any other evidence, then the jury wouldn't be considering what you said in your opening or your closing. You understand that?
Yeah.
Okay. Do you understand that even though you know some of the law around criminal cases and this and that, if you choose not to have an attorney, you are losing the value of an independent perspective on this case, someone who is not connected to what happened or didn't happen in this case.
What you mean by that?
One value of an attorney is that that person comes in and looks at the discovery and says, hey, I'm coming in from the outside. I wasn't there. I don't know you. I don't know Mr. Baker. I'm telling you right now, this looks real bad. There's surveillance footage and you're wearing a t-shirt that says Ricky Pierce and your fingerprints are on the gun and your DNA is at the scene. I'm making this up, but a lawyer could say all this and say, look, Pierce, you need to work this case out because the prosecution is going to run the bus over you and back it up and run it over you again with all this evidence. That's a lawyer having a hard conversation with you, if that's what the evidence was. But you also might have a good lawyer look at it and say, they have nothing on you. You were merely present. Baker had the gun. The video footage shows Baker shooting the guy, and you're standing there looking as scared as the poor guy who got shot. I don't know what the evidence is. I do know that having your own lawyer means someone who is independent, who isn't running the risk of going to prison, can look at this and say, this is a good case for you, or this is not a good case. You will never get that independent assessment of the strength and weakness of the state's case if you represent yourself.
Right.
You understand that?
Yes, sir.
Okay. Do you understand that the prosecution will be free to bring in the most experienced attorney it wants? I won't say, hey, Pierce isn't a lawyer, so you need to bring in a brand new prosecutor who's never tried a case before, so it's more even. Understand that?
Yes.
They could bring in the big guns, and that's your problem and not anyone else's. Understand?
Good.
Okay. Do you understand that I will not ever tell the prosecution to go easier on you as the opposing side because you're not a lawyer?
Yep.
I'll expect them to treat you as respectfully as they do defense attorneys because you ought to be, you're the other side, but they aren't going to need to pull punches with objections or anything like that. If they think something wrong has happened, they're free to object. You understand?
Yes.
Okay. Do you understand that if you are found guilty at trial, you will not be able to argue on appeal that you were a bad lawyer for yourself?
Understood.
Because that's a claim that a defendant can always make if he's got a lawyer. It's called ineffective assistance. See, you know stuff, but you cannot say I was ineffective, meaning Ricky Pierce was ineffective.
Right.
You may have been very ineffective, but you don't get to argue that if you're your own lawyer.
Understood.
All right, you're understanding all the stuff you need to. Do you understand that you will not get extra time to prepare for trial just because you're representing you're gonna have plenty of time. Trial's not tomorrow. But if you say, you know what, I need a year to get this done, I'm gonna say, no, you don't. You're not gonna get any more time than I would give the lawyer that I would appoint to represent you. Or if you hired a lawyer, I wouldn't give that lawyer a year to get ready. There's a family that's grieving because of a loss. You're sitting stuck in jail. And so we need to move this case along. I'm not going to rush it, but I'm not going to go slowly just because you represent yourself.
Understood.
All right. Do you understand? And this is something we've already talked about, but it's important we cover it again. Your ability to investigate this case and do legal research will be very limited by the fact that you're choosing to represent yourself and you're stuck in jail.
Yeah.
You got that? You appreciate that's a disadvantage.
Yeah.
But it's a disadvantage you're willing to eat.
Yes.
Okay. All right. You understand if you had a lawyer, you hired one or I appointed one, that lawyer would not be stuck in jail with you. That lawyer would be able to go out and you could say, hey, you need to go interview Fred Smith. And they'd try to find Fred Smith. And they'd have an investigator who could try to find Fred Smith. You understand that?
Yes.
You're going to need to figure out how to do that on your own.
Yes.
Right? Okay. Now, if you had a lawyer, you understand that that lawyer could give the opening statement for you, could do the jury, we call it voir dire, but questioning jurors in advance when you're doing jury selection, could interview witnesses, subpoena witnesses, prepare jury charges, do closing arguments, cross-examine the state's witnesses. A lawyer would, should, and could do that for you if you had a lawyer. You understand that?
Yes.
And you won't have any of that if you represent yourself.
Yes.
All right. Has anyone threatened you to get you to waive your right to a lawyer?
No.
Has anyone promised you something to get you to waive your right to a lawyer?
No.
Mr. Pierce, do you want to represent yourself, at least for now, in this case, understanding that the only way you can undo that is by saying, I hired someone. Here's this lawyer for me, because otherwise you're telling me, no, I got this. You understand that?
Yes.
And do you want to represent yourself?
Yes.
Okay. Well, I find, and I'll get this in writing and enter an order to that effect in the docket, that you're aware of the charges against you: murder, felony murder, aggravated assault, armed robbery, etc. The consequences you face if you're found guilty, up to life without parole. The advantages of having a lawyer: outside investigation, independent opinion, legal expertise, etc. The disadvantages of having no lawyer: hard to investigate, hard to do legal research. But I find that despite all those things, you have made a knowing, intelligent, as in you get it, and voluntary, no one's forcing you, waiver of your right to counsel, and you are exercising your right to represent yourself, and I'll grant you that right. Any questions about any of that?
No, sir.
Okay. We got, so two things. One, I'll make sure that, Mr. Abate, is this your case?
Yes, Judge.
Okay, that's your prosecutor. I'll make sure Mr. Abate gets to me as much paper discovery as they've got. Again, there's often lots of digital discovery, and I'm making this up. I don't know what's in the case, but let's say your cell phone was seized. They might have done a cell phone dump, and there's a big old file that lists all the pictures and texts, and sometimes, maybe not in this case, after something happens, Baker texts to Pierce, I can't believe we shot that guy. And Pierce says to Baker, hey, we need to not talk about this anymore. I heard the dude died. That's great evidence for the state, but that's digital evidence. And so that might not be something that can be handed to you to look at in
How would
jail.
I access?
So what you'll get is all the paper discovery as well as a list of what is the digital discovery: body cam footage, surveillance footage. And then you would let me know. We'll have a status conference so I can see how things are going. Hey, Judge, there's some things I need to watch. And we would set up a time when you could be here, and there'd be a laptop, and that stuff would be there, and you could watch it and take notes, whatever you need to do. It's not convenient for you, but that's how it works when you are representing yourself and you're stuck in jail. So my answer is not you can never see it until trial. It's just we have to develop a little bit of a workaround. And so you'd be watching it here. You can't just watch it anytime you want. We'll set up a specific time, and that's how you digest it. Okay? I'm not saying there's any digital discovery, but if there is, that's how we do it. So I'll get from the state the discovery. We'll figure out how to get it to you. Either we'll bring you over here and hand it to you. That's often my preference because it's on the record. I see you getting the discovery. Or through the sheriff's office, we'll get it to you. Are you at Rice Street?
Yes.
Okay, we'll get it to you at Rice Street. Mr. Abate, what would you say the ratio is in this case of paper discovery to digital discovery?
A lot of digital discovery. There's
Okay.
like Mr. Baker's cell phone extraction, and there's a lot of video surveillance, some of which this defendant, Mr. Pierce, is seen in high definition video shooting the victim in the head.
Okay, so there are things he'll need to see.
Yeah.
Okay. When you generate the paper discovery, would you please include, you don't need to list the description of each video, but 9 surveillance footage, 9 surveillance videos, 2 body cams, whatever the generic count is. So Mr. Pierce knows, and then he can be keeping track. Wait a minute, I've only seen 1 body cam and it says there are 2. We can sort that out. Thank you. So you'll get the paper discovery, and then clearly we're going to need to figure out a time when you can come here and watch it. You get to watch it privately. The prosecutor's not going to be there while you're doing it because you may have a reaction to it, and take notes, whatever you need to do. That's number 1. Number 2, are there things that you think we need to talk about now, or now that you represent yourself, are there instead things that you want to get in writing and file as motions?
Yes, I have 2 motions that I want to file. I have them wrote up now in my thing, and there's a lot of issues that I have to address as far as with me being a national, just putting it on a record for my benefits.
Okay, so let's do that. Let's do 2 things. 1, I want you to put on the record, we want to just do it. You're free every time we're in court together to remind me that you're American state national and you don't think that there's jurisdiction. But what I would ask you to do, you're going to share, it sounds like a fair amount right now, to get it on the record. We only need it on the record once because you will have made that record. And then in the future, all you need to do is say, hey, I rely on the record I made. You don't even need to state the date, but that I made before about my objection to jurisdiction or whatever you want to call what you're about to share. So I'll always let you make a record. But I will push back a little bit if next time I see you, like, hey, I need to make that same record again. No, you don't. You made it, and you only need to make it once. And then there's a transcript so that if you need to take something up on appeal, they only need to read it once. All right?
Would I get transcript from every court proceeding? Or how do that work? Do I have to file for it?
So
or automatically get it to me? I'm representing myself.
So every time Ms. Rivers is taking something down, we can create a transcript. We don't immediately generate transcripts because, for example, if you go to trial and you're found not guilty, we don't need to create a transcript of any of that because you're done. You go home. If you're found guilty, then we need to make transcripts of everything because all that goes to the Supreme Court for the appeal. Between now and your trial, we typically don't create transcripts unless, just as an example, let's say we had a suppression hearing and the lead detective testified and talked a lot about the work that she did on the case. Everyone wants a transcript of that because she's going to come back at trial. And if her story changes, then someone wants to say, wait a minute, you were in court 2 months ago and you said Mr. Pierce was wearing a blue shirt and now you're saying he's wearing a red shirt. Which one is it? And the jurors are wondering, why is this detective changing her story? But things we're saying today, that kind of transcript we'd make only if you're found guilty and we need to push stuff up to the Supreme Court. But it is being preserved if Ms. Rivers is here and doing what she needs to do, which she is. So why don't you briefly share with me the things you want to get on the record?
Your Honor, let the record reflect that I'm an American State National, which is a private American. I'm here on a special appearance to administer the affairs of the All Caps Trust. I am the living man, Ricky DeMond Pierce, and not the All Caps legal fiction, corporation, or dead entity. I stand on the land and soil jurisdiction, and that's the highest jurisdiction on the man. This is my oral request of me changing the court's jurisdiction over me here today. I have not contracted with the court in any kind of way, and I don't plan on contracting with the court in the near future. I have been forced to come here against my will and God-given rights under threats enforced by your government officials, which is kidnapping. Your courts have no jurisdiction over me, and I stand on the land and soil jurisdiction and have proof of it when I came to court on January the 30th, 2025. Your courts, plus in Louisville versus Motley, if any tribunal finds absent of proof of jurisdiction over a person and subject matter, the case must be dismissed. Your court's jurisdiction is the jurisdiction of the sea, which is the Admiralty and Maritime Laws, which is also a military tribunal, and the courts are known as a ship of war, a privateer, or a battleship. I am under public law, which is common law, which is also the law of the land, natural law, God's law. I have God-given rights that can't be violated, and the courts are under Admiralty and Maritime Laws, which is a foreign law to sea jurisdiction. See Article 3, Section 2 of the United States Constitution. And no living people live there, only dead persons, legal fictions, corporations, and dead entities. Because all cities are considered dead entities, which is another reason why you have to dismiss this case, because the living cannot be judged by the dead. Another problem the courts have, because my God-given right says I have to be tried amongst my peers and a jury of living people, which is American State Nationals, and also can't happen because our nationals is not under the court's jurisdiction and will not show one order because they hold a higher jurisdiction. In the original Constitution, Section 3, Article 3, Section 2 states that the United States, the corporation judicial power is under Admiralty and Maritime jurisdiction. And I am under the land and soil jurisdiction, and I have gave courts proof of this when I came to court January the 30th, 2025. I also mailed off my executive letter, the notice that President Trump sent out January the 4th of this year, letting all patriots know that these laws have been dissolved due to breach of oath, due to fraud and breach of oath for office. And I also mailed off a copy of my certified mail. I mailed off certified mail and have been received. I am also requesting your oath of office, Your Honor. The notice that Trump sent out goes as follows. Notice to patriots, date January the 4th, 2025. This is to inform all patriots that effective immediately, our government and government corporations are hereby dissolved due to breach of oath. Additionally, All statutory and foreign laws are also dissolved. The only legal framework that remains in effort are constitutional law as outlined in Article 61 of the Magna Carta and established common law. This directive is especially for corporate bodies and government workers. Any government corporate body, including police, judges, lawyers, and any individuals operating in these capacities must cease operation immediately. Those who continue to operate after this notice will be liable for prosecution for fraud and breach of oath. It is imperative that all government workers comply with this directive. Failure to adhere may result in serious consequences and even including potential military actions. I declare on the penalty of perjury on the public law of the United States of America, the de jure government, from without the United States of America, the de facto government, and without the United States of America, the corporation territories. I reject, renounce, and remove all powers of attorney granted to me or issued under my name prior to this day. My birth certificate was the only contract that subjected me to these laws, but the birth certificate contract is void because I was only a minor and had no knowledge of this contract when it was constructed, which makes this contract void, which means the court lacks subject matter jurisdiction over me. I am no longer an employee of the government, which is the corporation government. I declare on the penalty of perjury on the public law of the capital T, United States of America, the de jure government, that I reject, renounce, and remove any and all alliance to any king or prince, any foreign state, any foreign government or flag. I declare on the penalty of perjury on the public law of the United States of America, the de jure government, that I have never knowingly, wittingly, or voluntarily pleaded myself to any incorporated entity at all, but including but not limited to any incorporated church, synagogue, masjid, or temple. I declare on the penalty of perjury on the public law of the United States of America, the de jure government, that I have never knowingly, wittingly, or voluntarily pleaded myself of any foreign state, foreign sovereign, or separated myself from my birthright political status as American state national. I declare, publish, and affirm on the penalty of perjury on the public law of the United States of America that I am a lawful inheritor, acting with full rights and authority, responsibility, and honor now and always while my tenure on earth shall last. I, the living man, Ricky DeMond Pierce, affirm and declare that I have returned to my lawful birthright political status as a Georgian, and I have copyrighted and trademarked the all caps name, which is a trust and not the living me. I have occupied my executive office and never gave the courts any permission to use the all caps name, which is fraud. I have over 40 violations that the courts have committed upon me and my God-given rights as American state national. And I have counted over $800 million in violations over the time that I have been incarcerated at Fulton County Jail, these 150 plus days, and it's only adding up as I sit in Fulton County Jail against my will and consent. And they are as follows. 1. These are all combined municipal and territorial notices of violations against Americans with failure to perform any and all occurrences listed below in this section, starting at $10 million. A. Notice of claim of sole relief and remedy. B. Notice of violation of the Landman Act, attempted attachment and seizure of unregistered trademarks, Title 15, Section 1125, 8 and 11. Notice of violation of admiralty and maritime and prior cases, Title 25, Section 1331, 1, 2, and 12. D. Notice of violation for special maritime and territorial jurisdiction of the United States, Title 18, Section 7, 1, 3, 8, and 13. E. Notice of violation of the Postal Accountability and Enhancement Act of Title 39, Sections 1-3908 and 3621-3591. F. Notice of violation of presumption of the Public Vessel Act, Title 46, U.S.C.A. Appendix, Section 781 through 790, as originally enacted. G. Notice of violation of the False Claim Act, Title 31, U.S.C.A. Sections 3729A and 7. H. Notice of violation of the Foreign Sovereign Immunity Act, Title 28, Section 1602 through 1611. I. Notice of violation of the United States Statute at Large Act, Title 12, Section 411. K. Notice of violation of the Geneva Conventions by the United States Department of Defense.
Mr.
and United
Pierce,
States.
Mr. Pierce, I'm going to just pause you for 1 second. You were on K. How many letters? I want to make sure
I'm
you're almost done because we're getting into international stuff and that's getting a little far afield.
All right. 2, private easements fee schedule. Penalty for private use, $250,000. These fees will be mandated upon the informant listed on the warrant, citation tickets, arrest warrants, detention orders, and seizure orders. Compulsion to produce trade name or other identification materials. A, name, $50,000. E, fingerprints, $200,000. F, photographing, $200,000. G, DNA, $5 million. Blood sample, $5 million. Personal property, trespass, carjacking, theft, interference with commerce or trade. M, color law, $150,000. N, implied color law, $150,000. T, fraud, $1 million. U, fraud upon the courts, $2 million. BB, stimulating legal process, $1 million. Use of trade name and copyrighted protected material on threats, duress, and or coercion. Name written by informant, $250,000. Miscellaneous material written by informant, $500,000. Court appearance fee schedule. These fees must be paid immediately after my case is finished. Failure to pay fines and fees will result in an additional fee of $5,000 for breach of contract. Demand for appearance in court. My appearance on the protest and duress per hour, 1 hour minimum, $75,000. Use of trade name material.
How many more pages do you have?
I have quite a few.
Okay, so I'm wondering if, and I'm not going to curtail you too much, but you'll be able to file that, which will make it even more of a record if you want it to be filed, or you could give it to me and I'll file it for you. But that's up to you. What I don't want to do is I want to make sure we're moving your case forward, and this is pretty lengthy. It might be more efficient to have it filed into the docket so that we actually see, hey, there it is in the computer system.
I really need to get it on the record, and I need to file the motion to be able to address these issues also. I have the motions already wrote. If you give me a little time, I can get through it pretty quick.
Well, I don't want you to read too fast because Ms. Rivers needs to be able to take it down. Would you say we're more than halfway through, or are we not more than halfway through?
Yeah, we're halfway through.
Exactly half or more than half?
Exactly half, because it's 20 pages. I'm on 11 now.
Okay. Well, let's go. Don't read too fast, but don't read too slowly.
Trespass and failure to act fee schedule. Use of trade name material, name on the protest and duress, $25,000. Miscellaneous material, $25,000. Time uses for court appearance, 30 minutes on the protest and duress, $33,500. 60 minutes on the protest and duress, $75,000. 90 minutes or more on the protest and duress, $100,000. Trespass and failure to act fee schedule. Trespass by public officials, police officers, judges, detectives, attorneys, corporations, and other fictitious entities as well as any other who desire the contract. A, trespass on American homestead land, $10 million. C, failure of attorney to file requested FARA form, $1 million. Failure to accept American State National card, $1 million. Failure to honor God-given rights, $20,000. Failure to honor oath of office, $50,000. Failure to honor constitutional oath, $50,000. Failure to honor written and oral word, $5,000. Failure to honor no bond, honor a bond/no bond, $5,000. Detention from free movement and or cuff per hour, 1 hour minimum, $75,000. Incarceration per hour, 1 hour minimum, $75,000. Failure to follow federal and or state statutes, code, rules, and regulations, $50,000. Failure to set a claim upon which relief can be granted, $25,000. Failure to present a living injured party, $100,000. Total damages for each line set forth in a above schedule will be assessed as the total amount of damages as set forth herein times 3 for a total of all damages added to a 3 times the damage for appearance and other additional damages for a total of $1,019,631,000 US dollars.
1 billion, you're at to the B.
Yes.
Okay, that's a lot of money.
And that's just for the amount for me being incarcerated these 120 plus days. Your Honor, all laws are commercial, and all laws are not laws, but codes, statutes, mandates, regulations, and all the rest. And I'm a private American or not under commercial law. What's legal aren't law, Your Honor, and what's law aren't legal. And Your Honor, ignorance to the law is no excuse, and that goes on both ends, mine and yours. This declaration is valid, true, correct, and complete in all jurisdictional law, air, land, and sea. Your Honor, let the record reflect that if you are against this, this is warring against the Constitution. And warring against the Constitution is called piercing the veil. And piercing the veil is called treason. Treason is punishable by death, and there is no remedy for treason. Also, in Orange versus Independence, officers of the court have no immunity from persecution when violating the constitutional right. I am honored the United States of America, the Danjur government, the Confederation of the States.
Mr. Pierce, there's one phrase you've used a whole bunch of times, and I don't understand it. The what government?
The Danjur government.
What is, spell that?
D-E-J-U-N-E, space J-U-N-E, Danjur.
D-E?
J-U-R-E.
Oh, got it. Okay.
Danjur.
Yep. Thank you.
Okay, which is the Confederation of the States. And the Federation gave the United States, the corporation, the de facto government, the power to operate out the 10 square miles, which is in Washington, D.C. And any laws outside of Washington, D.C. is commercial. And private Americans are not under commercial laws. We are under public law, which is common law. My God-given rights has been violated by being forced to give my DNA, fingerprints, eye pattern, and blood DNA against my will. I never consented to them arresting me or detaining me after I put them on notice of my political status. Your Honor, United States, the de facto government, is a for-profit corporation, which means they have a Dun and Bradstreet number, and no corporation can interact with a living man under another corporation. Your Honor, it states that every man is independent of all laws except those prescribed by nature. No man or woman is bound by any institution formed by his fellow man without his consent. See case law, Cruden versus Neal, 2 N.C.338, May term 1796. Your Honor, in 1845, the then Pope and the British monarchs, both of whom were honor bound to act as trustees for United States Trust, and both of whom acted in gross breach of trust, agreed that the American experiment was not working. The whole idea of self-rule was antithetical to the idea of divine rights of a king's supremacy. So they signed a secret treaty of Verona and agreed to undermine the American government. The British Monarch Commercial Company, which controls the bankers and lawyers, issued license to lawyers to act as privateers. That's why the Bar Association requires licensing. Acronyms for bar mean British Accredited Registry. Anytime we see the word license, it means that someone in a position of rulership is giving someone else permission to do something that is otherwise illegal. In this case, the king gave the members of the Bar Association permission to act as privateers against American commercial vessels. Because the jurisdiction where they attack us is international, admiralty, and maritime commercial laws. And that's why you see the gold rings around the flag, around that war flag, because the war flag is a war flag representing that the government is at war with the citizens. See 1864 Naval Agency and Distribution Act. Again, also, the United States was incorporated by the Pope, and the laws we are bound by are foreign laws from Great Britain, which means that the United States, the corporation, got Americans to bind by laws from Great Britain, which is also illegal. That's why, again, you have BAR, which stands for British Accredited Registry.
What page are we on?
What am I almost doing now? I'm closing now.
All right.
I am 1, changed from jurisdiction of the courts. I have a high jurisdiction. 2, I am demanding to see the state of Georgia to show up in proper persona. This must be made by self and not an attorney. 3, I am demanding that the courts present a living injured party because our citizens are considered dead entities, corporations, legal fictions, and artificial persons. I am 4, I am requesting the judge oath of office and the first and last name of every court official in this courtroom before we proceed. I am demanding to see who gave the courts permission to use the all caps trust, which is a copyright and trademark. I'm putting the courts on notice that I have occupied my executive office again, and I'm standing in my full capacity as American State National, and I hold the highest court here today. I am demanding you give me a full relief for my case by either dismissing this case or giving me a bid bond signed and paid through my all caps trust. I am also filing an order of pro se ex parte with prohibition to dismiss my case for fraudulent practices, misrepresentation, and lack of subject matter jurisdiction. Your Honor, I, the petitioner, case will not being handled in the proper courts, which is common law courts. I, the petitioner, was not put on notice by a state-appointed attorney that my case will not handled in the proper courts. I, the petitioner, never signed a contract to be subject to the jurisdiction of the United States and or the District of Columbia. Again, the birth certificate and Social Security card are voidable contracts that was constructed when I, the petitioner, was a minor. So these contracts could have not been knowingly, voluntarily, or willingly consented to because as a minor, I, the petitioner, lacked the capacity to do so. Again, I am making a clear and unequivocal demand to petition the court, the state, to show up in the proper persona. The state is a legal entity, and a legal entity is an artificial person. And an artificial person is a corporation, which cannot appear in proper persona. See case law, Penhollow versus DOANES. This vagueness doctrine may invalidate criminal law for two independent reasons. First, it may fail to get a proper kind of notice that will enable ordinary people to know what kind of conduct to prohibit. Second, it may authorize and even encourage arbitrary and discriminatory enforcement. Your Honor, a basic principle of due process that a law is unconstitutional if its prohibitions are not clearly defined. Plus, I, the petitioner, cannot owe a debt in a bankrupt nation, and no title of nobility shall be granted by the United States. See the United States Constitution. Again, Your Honor, I, the petitioner, cannot have a fair and impartial trial when the judge, the jury, the bailiff, the district attorney, and public defender all work for the state and are one and the same. See the case law, the Maggie Hamlet case. Your Honor, the Constitution is a chapter of negative liabilities. Liberties, excuse me. It tells the state to let people alone. It does not require the federal government or even the state to provide services, even so elementary as maintaining law and order. See case law ID, period, CF.OLMSTEAD versus United States 277 US.438 and 478 1928. And again, Your Honor, any judge or magistrate who does not comply with his or her oath to the Constitution of the United States wars against that Constitution and engages in acts of violation of the supreme law of the land. The judge is engaged in acts of treason. See case law Cooper versus AURON, 358 US.1, 78 1401, 1958. Your Honor, the authentication of my birth certificate signed by the Secretary of State, the Secretary of Washington, D.C., and the Governor of Georgia is admitting that the government made a mistake by making me to abide by a void contract and subjecting me to the jurisdiction and laws of the government when I had no knowledge of this contract and was too young even know that this contract exists that the government tricked me and my parents into without our knowledge and consent. And the courts have a copy of my birth certificate authentication also. Your Honor, I am a private American, which is American State National, and cannot be represented by a bar attorney because an attorney is an officer of the court and will automatically subject me to the court jurisdiction.
And I hear you on that, which is why we had the first part of our conversation, and I've concluded that you've got the ability to and the desire to represent yourself. We'll do that. I appreciate you making that record. As you and I agreed, you won't need to do that again. You've now made all those objections, made it very clear that there's $1 billion plus, and I get it that that number is increasing. Every day you're in custody and people are trying to contract with you when they shouldn't, all that. You've made a healthy record of that. You're welcome to file things now because you are your own attorney. You can now file things of record into the docket. But when we see each other again for whatever the next court event is, we can use a shorthand where you can say, I renew the objections that I made on the record when I was last in court. And that way you're not going to need to break your vocal cords by going through that again. But that was very thorough, and I appreciate you making that record.
So is I can leave these motions here today?
So this one time, I'll take responsibility for filing things for you.
You know what, I'll wait, because I still have some other.
You want to do more work on it?
Yeah.
Okay. There is a way for you to file things from the jail, and they ought to tell you about that, but you can get things to the clerk's office. Don't mail them to me, because if you mail them to me, I'm not the clerk. They won't get in the docket. They go into my inbox, and I've got my Pierce collection. You should also know if you send things to me, I probably need to send them to the prosecutor as well, because we can't have what we call ex parte conversations. In the same way that the prosecutor can't call me and say, let me tell you what Pierce did. That won't happen. If Mr. Abate wants to talk about this case, you need to be in the loop as well. And so we'll bring you over here, or if it's real simple and technical, we'll get you in a Zoom booth so you can see and hear. But if it's anything substantive, you'll be here in person in open court for that. Okay? So what I see as our next steps, then I'll see if the prosecutor has anything else, and I'll see if you have anything else, is that I'm going to get a scheduling order in that gives a deadline for Mr. Abate to get together the paper discovery and then a list of what the digital discovery is, and we'll figure out how best to get that to you. I need to enter an order that says you get to represent yourself, so that's in there, and then we move forward.
Okay, cool.
What about you? Yeah.
Last time I was here when I went to trial, they had where I went to the law library and look at video footage. That's not possible anymore. Well, yeah, I don't know.
Meaning you went to the law library at the jail?
Yeah.
And you were able to
They had an officer supervise me to watch the videos.
Okay, why don't you ask? That's a question you need to ask the folks out there. I don't control the sheriff's security protocol. They may still do that. They may have cut it off because someone said it's video footage and instead it was an adult movie or something. And that's not you, but someone may have done something that abused that privilege. So ask, and if the answer is there's a way to do it, we'll make it happen. What I do know works, because I did it the last time I had a pro se defendant, is that he came here and we had a laptop. The prosecutor brought in a laptop and said, here's the directory, here are the 5 videos. Prosecutor went away and you hit play and you got to watch them. Took whatever notes you wanted and then you went back. So worst case scenario, we'll do that. But if you figure out there's a way to do it at the jail, then we can talk about making that work.
Who I need to contact? I think I need to contact the sheriff office, the sheriff or something.
It would be someone at the jail. I don't know who you talk to if you want to go to the law library or if you've got a headache and you want a pain pill. I would talk to staff out at the jail. Hey, if I want to do X, is there a way to do it? If they say there's not, then we got to do it over here. Okay.
Understood.
Any other questions?
No, sir.
Mr. Abate, what do we have from the state?
So on the last issue you just, or Mr. Pierce just raised, I don't believe the jail does that anymore.
I don't either, but
the USB and or CD, they just don't allow that kind of, what they would call contraband at this point. So we can act, or he can ask obviously, but just for efficiency purposes, I think.
Sure, with the law library, just see the law library still do it.
you should ask, but don't be disappointed if the answer is no. I think there were issues with, a USB drive is so small and it ends up in someone's pocket and then it's on the 7 North and I'm not saying you did.
Is it part of me possible I ain't got to tell you, they can stick it in, sit there, with me to watch the whole video.
Hey, if you can sell it and make them do it, that's great. I'm not saying no. It's not my call. It's not his call. That's 100% the chief jailer's call. And they may have said, we're not doing it anymore. And if they're not, then you come over here and we'll make it happen. Anything else?
No, Your Honor, I'll get paper discovery this week.
Great.
To Your Honor, and then I will, in abundance of caution, put all the digital media on the drive just in case.
Good.
And regardless.
Well, and that would be helpful because if you include that with the paper discovery, then you don't even need to be in. If we can get our hands on a laptop, then we'll let you know when Mr. Pierce is coming over, but we may not need to impose on you to show up with the stuff loaded on a computer. I don't know. I don't want to get in the middle of the technical stuff, but I do want to enable Mr. Pierce to see what the state has.
I have no problem logging in the laptop when he's here. We did that with Judge Ingram on multiple occasions, and it seemed to work pretty efficiently.
Good, I think so.
And Mr. Pierce is an A&C recidivist, so he is facing, if convicted, a mandatory life without parole sentence.
Okay, and is there a recidivist notice in the docket?
Not at the moment. I intend to file it.
Okay. Mr. Pierce, I'm going to translate that for you. You may already know what it means, but because of your criminal history, the state has the ability to file a pleading, which it sounds like they're going to do, that if you're found guilty, and all this is contingent on a jury finding you guilty. If they find you not guilty, none of this matters.
Okay.
But it's a big if. And if a jury comes back with guilty, I had mentioned that the maximum possible penalty was life without parole. But if you'd never been in trouble before, that's not a mandatory sentence. Life, I'd have to impose life, but I have the option to choose between life without parole or life. Unless you've got sufficient criminal history and the state files this notice. And if they do that and they've got certified copies of your convictions, then that takes that discretion away from me. And the only sentence you can get is life without parole. And that may be where we end up, but they haven't filed it yet. When they do, we'll figure it out. But it's important that you be on notice of that, because sometimes the defendant thinks like, hey, you know what, if I'm found guilty, it'll be life. That's a long time, but it's parole after 30 years. But if life without parole is the only option, it just may make you think differently about the case. Don't know, but we'll keep you posted. Okay? I appreciate everyone's patience. Mr. Pierce, we'll get you back here either because you filed something we need to talk about, or it's time for you to look at the digital discovery. All right?
So, question before we go. How much do I have, like a certain amount of time to file all the motions that I need to file, or how do that work?
So there'll be a scheduling order that comes out, and we'll need to make sure it gets to you, and that's got a deadline for the state to get discovery, and then you've got a deadline after that, so you can see all the discovery to file motions. Okay. You can always file a motion later on. I just don't promise you that I'll get to it before we get to trial, because you want to avoid a defendant just before trial. It's like, oh, no, I got another motion and another motion. So you're going to want to start filing things. If you already have them here, put them down on paper and start filing them. But you'll get this scheduling order that's got the cutoff where anything filed after that date is out of time, and I can choose to ignore it, and I don't get in trouble with the Supreme Court.
Okay.
Okay.
And question, I know I've been having a conflict with attorneys, so does my time from this day today on forward start me to file my speedy trial? I know it's a certain time frame for you to file a speedy trial. So does that time frame start now, since we have an understanding?
Right. It started from when you were indicted and not now. So you can still file. You can file. Well, I'm not going to give you advice. You should file what you want to file, and we'll work through whether it's a mandatory speedy trial or if it's a discretionary one. But I'll tell you, no one's interested in slowing this down. Mr. Baker is on a trial calendar that starts in a week. Okay. And I'm having to slow that down because really you two ought to be tried together, unless someone can convince me that you shouldn't be tried together.
You're going to try it together even if I'm not a citizen?
Yep. We can try a citizen next to a non-citizen. That's not, the only reason you don't try people together is if there are reasons why there's some evidence that can only come in if they have separate trials. But I leave that up to the lawyers and you to work through that. My default is always to try co-defendants together. And Mr. Baker's case is ready for trial. So if you say I want a speedy trial, no one's going to say, no, let's slow it down. They'll want to move it along. But you file what you want to file, and I promise you we'll work through it. Okay?
Okay.
All right. Thank you, deputies. You can take Mr. Pierce back.
Sorry, I appear to have a fly in here. Okay, buddy. I can see you. Right, just take it easy. I'll bring you down. That's it. Relax. Wait, you're going around in circles. Oh, I see you've lost a wing. That's tough. Right. Okay, let's try coming in a bit slower this time, huh? Hold it. No, throttle back. Throttle back. Left rudder. You're diving too steep. You're never gonna make it. Would be an air traffic controller.
And thanks for hanging out with us on Facts or Frauds. Make sure you hit the thumbs up button, you're subscribed, and ring that bell. Also, leave a comment in the comment section. Tell me what you think. And a major thank you to every one of our Facts or Frauds channel members. If you'd like to become a member, just hit that join button right next to subscribe, or click on the link in the description. And if you're still hanging out, thank you. I appreciate you all. Make sure you hit the thumbs up button, subscribe, and ring that bell. Also, leave a comment in the comment section. Tell me what you think. If you'd like to become a member, you can do that too. Till next time, I'll see you soon.